Welcome to In and Around War, a podcast of the Geneva Academy of International Humanitarian Law and Human Rights on contemporary issues related to wars.
Greetings and welcome to another episode of In and Around Wars, a podcast from the Geneva Academy of International Humanitarian Law and Human Rights, where we discuss contemporary issues related to armed conflicts. My name is Eugénie Duss. I am a research fellow at the Geneva Academy, and today I'm very pleased to welcome Jelena Aparac, lecturer and researcher on business and human rights in armed conflicts, including at the United Nations Senior Women Talent Pipeline, and Stavros Pantazopoulos, postdoctoral researcher with the Toxic Crimes Project of the Erik Castrén Institute at the University of Helsinki, and senior research fellow at the Hellenic Foundation for European and Foreign Policy. We are recording this podcast in the studio of the Geneva Graduate Institute, one of our parent institutions, and will continue the conversation we start at our recent IHL talk, The Prosecution of Ecocide and Other Environmental Crimes, the State of the Law and the Ways Forward. Jelena and Stavros, thank you so much for coming today to speak with us. During the IHL talk, we extensively discussed the definition and prosecution of ecocide and other environmental crimes. Today, I would like to discuss recent and ongoing proceedings addressing climate change outside the criminal framework. Jelena, could you provide us with an overview of the most recent and ongoing proceeding on climate change taking place at the regional and universal level?
Thank you, Eugenia. Yes, absolutely. Let me start first by mentioning the Human Rights Council that adopted in March 2008 the first climate change and human rights resolution. And since then, the Human Rights Council adopted more than 8 resolutions linking the climate change issue to human rights. And it was very important and a good start that paved the way to other actions. In 2016, Chile and Colombia submitted a request for an advisory opinion to the Inter-American Court for Human Rights to clarify the scope of state obligations in their individual but also in the collective dimension in order to respond to the climate emergency within the framework of international human rights law. Also, Inter-American Court looked into differentiated impacts on various groups by climate change. Inter-American Court found that the right to a healthy environment is indeed a human right, and the opinion also noted that environmental degradation and climate change both affect human rights. The court also discussed the responsibility of government for significant environmental damage that cause within and beyond their borders, and this element of going beyond the borders, the extraterritorial aspect, was very important in this case. And as you are aware, the European Court for Human Rights was the latest significant progress, where the court recognized the negative impact of climate change on human rights in its decision from April this year, 2024. And there are in total about 12 cases before European Court of Human Rights. Some have been already dismissed, some are still pending. It remains to be seen how they are going to evolve. We have 2 pending advisory opinions, which are very significant. One before the International Tribunal for the Law of the Sea, that was brought by the Commission of Small Island States, requesting the tribunal to provide advisory opinion on climate change based on the Convention on the Law of the Sea. And the tribunal will deliver its opinion on 21st May this year, so just in a few days. So it's very exciting to follow this news just after the European Court of Human Rights. And we have the ICJ, International Court of Justice, advisory opinion, which was triggered by the General Assembly resolution that was adopted in March 2023, requesting the International Court of Justice to give an advisory opinion on the obligation of states in respect of climate change. And the questions that were put to the court was, what are the state obligations and what are the legal consequences under these obligations with respect to states, including small islands, and in respect to people and individuals of the present and future generations. And in its press release of 12 April 2024, so just a recent press release, it's interesting to note that the court informed that they received 91 91 written statements, the highest number ever to have been filed in advisory proceedings before the court. So we are seeing increase of various cases, be that judgments, advisory opinions, regional, international level, on climate change specifically and linking climate change to human rights.
Thank you very much for this comprehensive overview of all the proceedings that are taking place or that were recently delivered. Turning to you, Stavros, I would like to focus on the European Court of Human Rights recent judgment. He delivered a landmark judgment on climate change in the case of Verein Klimaseniorinnen Schweiz and others versus Switzerland. And the recent episode of the podcast, What Matters Today from the Graduate Institute, extensively addressed the background, findings, and implications of this judgment. But could you explain why, although the applicant alleged violation of the right to life and the right to health, the court has only admitted a violation of the latter?
First of all, many thanks for your kind invitation, Eugénie. It's a pleasure to be here together with you and Jelena and be discussing these very crucial issues. Turning to your question about the dual basis, first of all, Article 2 on the right to life under the European Convention of Human Rights and Article 8. These are the common two bases alleged by applicants when it comes to the environmental jurisprudence of the European Court of Human Rights, which by now I would say is very much well developed. So the court, in this landmark case, as you rightly mentioned, and I fully concur with this statement, built on this jurisprudence. It's environmental human rights jurisprudence, if we can call it like this. Now turning to the substance of the claims when it comes to Articles 2 and 8, the first issue here is that the court determined that the drawbacks, the deficits, the shortcomings on behalf of the Swiss government when it comes to combating the adverse effects of climate change could, of course, trigger the applicability of both Articles 2 and 8. Nevertheless, in a very important move, the court determined that it will not deal with alleged violations under Article 2. First of all, because it would have to determine life-threatening, as it says, consequences that could trigger the applicability of Article 2. And this would be more questionable. This is how the court puts it. And I think this is a very important statement, showcasing how the court approaches this case, the factual matrix before it. Of course, at the end, it identified the violation on the basis of Article 8, but it seems that it was not ready at this point of time to make a determination on the basis of Article 2. And to a great extent, in my view, this makes great sense. We could see this as an incremental development. So building on the environmental human rights jurisprudence, as we mentioned before, and now moving to the territory of climate change litigation, a very important landmark move. Nevertheless, triggering Article 2, perhaps it is too premature to make such a determination, also on the basis of facts and, of course, of the availability of scientific evidence. Nevertheless, and this would be my last point in relation to the interplay between these two articles, it is important that the court identified that there is a common core between these two provisions, Articles 2 and Article 8, with respect to the positive obligations incumbent upon states on the basis of these two articles. And in the judgment, the court undertakes a detailed analysis to identify what these positive obligations are. So to sum it up, a common essence when it comes to positive procedural obligations stemming from these two provisions. Nevertheless, at this point of time, it seems that we are not yet ready to identify a violation on the basis of Article 2, but to be sure, Article 8 suffices for our purposes.
Thank you so much. It seems also that the court granted standing to the association, but not to the individual applicants. From this point of view, creating an association to bring a case therefore seemed to be a good strategy. Jelena, what are your thoughts on this issue? And should civil society keep playing the leading role in the fight against climate change, or should individual claims be given the same weight?
I think that's a very important question. If you look at all the proceedings that have been instigated at regional and universal level, we can actually see that states, and in particular small island states, have been playing one of the leading roles in requesting the advisory opinion and pushing the international agenda to focus on these issues of climate change and human rights. Not only on human rights, but even broadening it to larger human rights and cultural rights, including, because obviously if you have the whole island disappearing, entire groups and their culture and their cultural heritage will disappear with that island. So they have been playing, small island states and other states have been playing a very important role in triggering various proceedings. But NGOs too, you are right. NGOs and civil society are fundamental in making the progress and advocating for stronger measures tackling climate change. You have a perfect example of Ecocide Foundation that has been working extensively on promoting the integration of the ecocide definition into domestic legal frameworks and have done so quite successfully so far in many places, in many countries. So NGOs and civil society do play a key role. When we look specifically at the European Court of Human Rights and the dismissal of individual claim, it's not necessarily automatic. Individuals can still have standing in climate change mitigation cases before the European Court, but only if there is two criteria, as the court has mentioned: a high intensity of exposure of the applicant to the adverse effect of climate change, and a pressing need to ensure the applicant's individual protection. So the court did not entirely exclude this option. It has given a stronger weight to the civil society. And you could argue that it makes sense because the court has limited the actio popularis. Otherwise, who is to say that you or maybe Stavros could initiate a climate change proceedings on my behalf? So court has adopted this position, excluded actio popularis, and it has done so consistently, even in the cases where it dismissed the cases, it has took this position. So individual focus, locus standi in Swiss case has been dismissed, but it's not necessarily the final option in future cases if the conditions are met, as mentioned by the court.
Thank you very much. I think I would like to address now with you, Stavros, from my point of view, a related issue. The court has taken into account the vulnerability of specific groups to the adverse effect of climate change. Similarly, the advisory opinion request on climate change before the International Tribunal for the Law of Sea was submitted, as mentioned by Jelena, by the Commission of Small Island States. There seems to be a trend toward focusing on specific affected people and entities. What are the pros and cons of such approach, and in particular, should the adverse effect of climate change on human rights be a matter of all?
Yes, this is a great follow-up question. And it's true that vulnerability holds a crucial role when it comes to addressing climate change, either through the means of human rights litigation or through other means. So vulnerability, a core tenet, and of course we can already identify this term in Article 7 of the Paris Agreement. One of the main objectives as enshrined in this convention, in this international treaty, is to reduce vulnerability with respect to climate change. So we see here, we could perceive the ruling of the court as a way to integrate this goal within the human rights language, within the European Human Rights Convention, in line with its mandate. And I think here comes one of the limitations, meaning that we are employing strategic litigation on the basis of human rights. This is a human rights-based approach. So we might end up with a definite binding ruling, as it is the case we are discussing, the Verein Klimaseniorinnen case. On the other hand, you take all the pros of the human rights vocabulary and machinery, you also take the cons with it, which means that, as Jelena rightly and very eloquently elaborated, the requirements under human rights law will first have to be fulfilled. For example, when it comes to identifying a victim in the sense of human rights. If these requirements may make sense under human rights language, under perhaps an individualistic approach, human-centered approach, when it comes to collective harm, perhaps they are not so sufficient at this point of time. Nevertheless, we know that the court identifies itself and the convention primarily as a living instrument subject to evaluative interpretation. So perhaps this is something that can be elaborated upon through interpretation in the years to come. But at this point of time, again, this is one of the shortcomings, if we can put it like this, of the human rights-based approach, which at the moment seems to be the dominant one, the lingua franca, as many scholars would have put it. And of course, this goes back to another discussion, to what extent human rights vocabulary, language, the machinery, might conceal the potential of other vocabularies, potentially emancipatory vocabularies, for example, the ecological one. This is a discussion originating in the critical legal studies scholarship. But of course, perhaps this ship might have sailed. By now, it seems like that this is the way forward when it comes to climate change litigation and other kinds of strategic public interest litigation. So this is the first point I would like to make. And the second, very much related to this one, again goes back to the requirements under human rights instruments and the applicable law, or for example, the pending advisory opinion you discussed before with Jelena, before the International Tribunal for the Law of the Sea. Of course, it is the small island states triggering this one. This could also make much more sense when it comes to the protection, for example, of the marine environment, etc., within the law of the sea. So these are the primary beneficiaries, victims, potential victims, etc. So it makes sense that they will be the first to trigger this kind of action. Nevertheless, we should always bear in mind that these are international courts and tribunals operating within their own mandates under specific rules and statutes, for example, and also under delineated applicable law. So all these claims will have to be tailored by reference to these applicable law and the context within which these courts and tribunals operate, so as to render meaningful outcomes. And I think one of them is the case we are discussing, the Klimaseniorinnen case.
Thank you so much. You put perspective also into this interesting issue. I think it will allow us to turn to another topic, unfortunately with a more negative touch, I will say. Jelena, I think it is fair to say that there is a serious imbalance between, on one hand, proceeding before human rights courts and the International Court of Justice, and on the other, the investor-state dispute settlement system. States are required to act upon climate change, while investor-state settlement system put climate action at risk by awarding large amount of compensation to investors against states adopting stricter environmental and climate measures. Could you tell us a bit more about it? In particular, how should we resolve this contradiction?
Wow, how we should resolve this contradiction? It's going to be up to state. It's not going to be an easy task. But let me just restart by highlighting what Stavros just said. International courts and tribunals are indeed independent, and they can adopt its own opinions and judgments. There is, of course, a dialogue, and they do follow each other's cases, but they do, as Stavros well mentioned, have different legal bases when they bring their opinions or judgments. So there is no doubt that the European Court of Human Rights judgment in case against Switzerland will influence the current pending advisory opinions and other judgment to come. It will very likely have influence on domestic proceedings within the states of the European Convention on Human Rights, and it remains to be seen how. But having said that, you are right. There is a true unbalance in the system we're seeing today between the human rights-based system, and I take this in a very broad sense, human rights, International Court of Justice, international public law, even potentially international criminal law, as the prosecutor is looking into environmental policy as we speak. But there is also another element, another side to it, and this is the development before investor-state dispute settlement tribunal. States are adopting indeed tougher environmental and climate measures, such as refusing oil and gas explorations of mining permits, and it will bring more climate-related investor-state dispute cases. According to the UN, and let's just look into the statistics, in 2000, there were only 12 cases related to environment that were brought before the investor-state dispute settlement. In the period of 10 years, between 2000 and 2010, there were 37 cases. And in the period, again, of 10 years, between 2011 and 2021, there were 126 cases against states that adopt climate measures or environmental friendly legislations. And just to give you an illustration, in 2022, the Italian state has been ordered to pay 190 million of euros to the UK-based oil and gas rockhopper exploration under the controversial Energy Charter Treaty, which allows fossil fuels to sue states over climate protection measures that affect their profits. This doesn't end here, it goes further. The compensation that was rewarded at that time to the rockhopper explorations was almost 9 times more than their initial investment. It does not end here. We have seen that the cases before the European Court of Human Rights, and Stavros mentioned it, have been dismissed because there is a human rights architecture in bringing cases, one being the request to exhaust local remedies before bringing the case to the European Court of Human Rights. So individuals have seen their claims rejected by the European Court of Human Rights because they not exhausted local remedies. When it comes to investor-state dispute settlement, investor is not required to exhaust local remedies before taking that state to the investor-state dispute tribunal, which is an international tribunal. So we have a paradox of where individuals cannot bring claims unless they have exhausted local remedies, but we don't apply that for companies. We have state sovereignty that is affected by it because the state courts did not have the opportunity to even look into the case, even less to dismiss it. And we have state sovereignty that has been questioned because if the state adopts legal framework that is environmental friendly and climate change friendly, as we are asking states to do, then they find themselves paying millions, even billions of dollars of compensation to multinational corporations that probably in some cases have even more money than some states. So we are in this paradox of balancing international economic law and international human rights law in the context of climate change. And it's very risky, it's very dangerous how it's evolving, as we are going one step forward before human rights mechanism and then 3 steps backwards in international investment dispute settlement. And that, I think, will come ultimately to states to address collectively.
Thank you very much. And I agree, it's a very worrying trend that must be addressed by state. To both of you, I would like to ask a last question. If we look at the ruling by the European Court of Human Rights, this judgment is a landmark in the field of climate change and human rights, but it also underlines that states, Switzerland in this case, are not doing enough in this area. In your opinion, what measures should states undertake to ensure that they meet their obligation under climate change and human rights law? And do you have any, to end on the positive note, any positive development example of good practice or other initiative to share related to this?
I could start with this one, the forward-looking perspective, if we can put it like this. First of all, it should be clarified that the European Court of Human Rights, could not have mandated concrete measures, of course. This would be beyond its mandate, beyond its ambit. It makes sense. These are positive obligations imposed on states. The choice of means, of course, lies with them. And this is also clear when it comes to the climate change regime per se. States mostly have procedural obligations to report their contributions to greenhouse gas emissions, etc. But the choice of means on how they will reduce these emissions, of course, lies with them. The problem in this case was that the Swiss government was not ambitious enough, first of all, and second, even to the extent it was trying to implement some policies, it was not doing that in an appropriate and timely manner. That's why it fell short of its obligations under the European Convention on Human Rights. So choice of means lies with states, and furthermore, they also enjoy a margin of appreciation when it comes to how they will implement these obligations. Of course, this may be subject to judicial review, makes sense, if they have exceeded this margin of appreciation, and this is what the court did in this case, but this is the point of principle, choice of means and the margin of appreciation with the state. What the court did here is to elaborate, as we mentioned before, building on its jurisprudence relating to Articles 2 and 8 with respect to procedural obligations, for example, the obligation to adopt specific measures, that specific timelines, specific time frames, to monitor these time frames, to establish, for example, carbon targets, intermediate targets, and this was also a crucial point because we know now that the main motto, if you wish, is the one of net carbon emissions by 2050. But of course, up to that point, this is a transition phase, and there should also be in place intermediate targets as well as sector pathways. So this is what the court could do, and it did so in the case at hand. I suppose this will happen also in future cases. Nevertheless, this was also a special case when it comes to the Swiss government. There were some complications with the referenda addressed to the Swiss people, etc., that in a way indirectly hindered the government from fulfilling its obligations under the climate change regime, and also, of course, because of its shortcomings. Nevertheless, when it comes, for example, to European Union states, perhaps most of these measures identified by the court in this judgment, perhaps these states are already fulfilling these obligations, for example, under the EU climate law, because these are binding obligations for them, for EU member states. So just to put it short and to yield the floor to Jelena, because I spoke too much, the court made us wiser to a certain extent within the scope of its mandate, but the exact measures and best practices, of course, will have to be determined by states.
Yes, I agree, and there's not much really to add, if not to say the civil society plays a crucial role in both prevention as in bringing the accountability cases potentially. And prevention is what we would actually favor, right? We want to prevent the further climate catastrophe rather than finding ourselves in the midst of it or finding the accountability. Through legal frameworks, adopting legal frameworks at domestic level, but also international level, and by bringing the accountability cases. We need to continue that. This is very important. General Assembly plays clearly an important role as a forum where these issues can be discussed and where it can be even brought to the International Court of Justice. It's going to be very interesting also to see how these two courts are going to position themselves, though only advisory opinions, so no legally binding, they will be nevertheless very important authority and influence for other case law. And it's going to be very interesting to see also how they will align, in particular on the issue of application of Convention on the Right to Sea, because both have that reference, both Tribunal for the Law of Sea and International Court of Justice, and how, and hopefully the International Court of Justice will find a way to address this balance between international economic law and international human rights law, because it has enough of instruments that was as a reference to the case, including the issue of due diligence and the role of corporations and how the corporate actors should act after the advisory opinion, or how states should ask them to act or adopt relevant measures. So it remains to be seen. We have seen the progress, some things have been done, but we are still a long way to go, and we all play key roles. Corporate actors themselves, they have to adopt their correct behavior and measures, states as well, but civil society should not give up on that.
Thank you very much. And I appreciate that we could end on a relatively positive note and at least a sign of hope. Thank you for sharing your time and your expertise, Jelena and Stavros. It was such a pleasure to exchange with you again on this very important topic. Thank you for tuning in to this episode of In and Around Wars. You can find other episodes on the Geneva Academy website, where you can also subscribe to our newsletter and find out about our IHL Talk event series. Thank you.
Thank you.
You've been listening to In and Around Wars, a podcast of the Geneva Academy of International Humanitarian Law and Human Rights. If you've enjoyed this episode, don't forget to subscribe and stay tuned for more inspiring conversations. You can also check the Geneva Academy's website, geneva-academy.ch, to find more resources and upcoming events on contemporary issues of international humanitarian law and policy.